Good morning, everyone. The first case on the court's calendar this morning is 36873, Richard Bennett Tabish and Sandra Renee Murphy, appellants versus the state of Nevada. Each side is going to get 40 minutes. Both appellants are going to take 20 minutes apiece, and you'll have the appropriate warnings when your 10 minutes are up, and we'll try to remind you about any time you wish to reserve.
Thank you, Your Honor. May it please the court, my name is William Terry. I represent Richard Tabish in this matter. We appreciate the court's courtesies that you've extended to us in reference to the extensive briefs and additionally the additional time that you allowed us to argue. We recognize that the briefs contain in excess of 20 issues. Quite frankly, based upon the time duration, we do not have time to discuss each of those issues, but that does not mean that we don't feel that each of the issues are very relevant and that the court should give due weight to each of the issues that have been raised, whether we address them in oral argument or not. With the court's permission, I'd like to argue for approximately 10 to 15 minutes and reserve at least 5 minutes for purposes of rebuttal. An extensive amount of the briefs deals with the issue of jury misconduct. And what you have in this case is not a situation where you're faced with only one issue of what we suggest to you as jury misconduct, but multiple issues. We've attempted to provide you, for brevity purposes, with the diagrams that are in front of you, plus each of you should have received a copy of these independent. When we deal with the issues of jury misconduct, we're dealing with constitutional standards. We're dealing with constitutional issues that have an effect not just upon a defendant, but upon the state of Nevada. Some of these rules which we're going to be providing you, which are provided in the briefs, they work as equally for the state as they do for the defense. The rule that says that when a judge has a conversation with a jury, both the state and the defense must be advised about that. And that's because the essence of what we're attempting to do is to make sure that both sides are provided with the opportunity of a fair trial. What we would suggest to you that in this case, you are dealing with issues not just ones that deal with Sixth Amendment rights of a fair trial, but confrontation rights, rights to cross-examine, the assistance of counsel, and due process. And again, unlike many of the cases where we're not just dealing with one issue, we're dealing with multiple issues here. You have extrinsic law, you have extrinsic evidence, you have a juror, at least one, that gives an opinion based upon her business knowledge that goes to the heart of the defense that was set forth by Mr. Tabish. And you have the cumulative effect of each of these errors that rose to a jury verdict of guilt after 8 days worth of deliberation. Jury misconduct is a term that is often utilized, but when we deal with what the standards are and what the test is, we're going to suggest to you that the test has been sufficiently met in this case. Your honors have addressed the issue of what we have to do in the Huey case, H-U-I. And that's as a result of the Chapman case from the United States Supreme Court. And you have to look at three factors: whether or not the issue of innocence or guilt is close, the gravity of the charge, and third, the quantity and quality of the error. And it's usually that third element that causes the court the most amount of concern. If you look at those elements only in this case, you have the issue of guilt or innocence where the state acknowledges that their case is based upon purely circumstantial evidence. They acknowledge that. There was never a showing, for example, as to Mr. Tabish, that he was present on that September 17th date when it was alleged that Mr. Binion died. You have a situation where the 8 days deliberation in and of itself shows that this jury was having difficulties. You have the situation where the votes are specifically noted, not just from the jurors, but according to the testimony of the jurors as to what sequence the votes were taken. And the first vote in this case was 7-5 for acquittal. And everything seemed to happen the second and third day that evolved into this case, with a culmination occurring on the 8th day when what we suggest, the coup de grace, so to speak, was done, and that's the depraved indifference and the fact that the last holdout juror was convinced based upon that. The rule is that you have the right to look at overt facts. We cannot impeach a jury's verdict by their own statements, so say the law. But you have the right, and you've held this in innumerable cases, to look at what the overt facts are. And the thing that you have here is the documentation. In dealing with the second issue, which is the quality and quantity of the error, I would suggest that unlike Judge Bonaventure's approach, and we would suggest that he utilized the wrong standard, that the Ninth Circuit standard, which has also been approved by the Supreme Court, is the one that should be utilized, which is a five-pronged test. Whether or not the material was received, and if so, how, the length of time it was available to the jury, the extent to which the jurors discussed and considered it. Fourth, whether the material was introduced before the verdict and whether or not it made a difference. And fifth, any other matters which your honors think are relevant to the consideration of the issue of jury misconduct. And that fifth standard is really worded, any other matter bearing on the possibility of whether or not extrinsic material or extrinsic law was utilized for purposes of discussions by the jurors. The Ninth Circuit in the Peterson case, which we've cited before, your honors, indicates that if there is a reasonable possibility that extrinsic evidence could have affected the verdict, a reversal is required. You have cases such as the Dershowitz case, the leading case out of the California Supreme Court, where there was a situation where a retired police officer was on the jury and he advised the jury as to what the law of robbery was. And it's an interesting case because what the court found was that it is not so much whether or not the jurors relied upon that extrinsic law advice, it's the fact that it was brought in the first place, and a reversal occurred in that case. With your permission, I'd like to go through the different items that are set forth within this document. The first one can be considered as three errors that occurred during the second to third day of the trial, and those are the utilization of extrinsic documents, which are called the instructions in the Binion case, the extrinsic documents, which are referred to as the charges, and the extrinsic documents, which are referred to as the witness summary. Now, the witness summary we have brought to your attention only for purposes of this. Each juror certainly can rely upon his own notes, but when those notes are utilized by other jurors in place of what their own recollections were, that is a matter that must be taken into consideration by this court. Most critically, when these documents were prepared, and please recall how these documents were prepared. They were prepared by a juror, 12 copies were made, they were provided to each of the jurors, and at least 5 of the jurors testified that they relied upon those instructions, and upon what the charges were.
Mr. Terry,
now yes?
Under our case law, is that portion of the affidavits that talk about what they relied upon or what they discussed, not delving into the mind of the jury, which is not prohibited, which is prohibited under our case law?
Yes.
How then do we consider?
We were not permitted, you have a number of factors, Your Honor. We were not permitted to ask the question, did this have an effect upon your deliberations? But what the court can consider, and it's clear, is that you can consider the objective facts that are set forth, just like in the California Supreme Court case that was cited. You had individual jurors that testified as to what was related to them as being the law, not how it affected them, and that was the error. So in this case, in just dealing with these three issues, you have the objective facts, which are the documents themselves, somewhat uniquely kept, I might add, because if you recall, the bailiff was directed to provide to the defense each and all of the documents. He went to his locker and retrieved these. And these are the extrinsic documents that we're referring to, these three sets. So to answer Your Honor's question, you have the extrinsic facts, that is the documentation, just as you have the extrinsic facts, which is the timeline. The timeline.
But you would concede that your previous statement that the juror relied upon these is not something we can consider.
You cannot consider, based upon the case law, whether or not that had an effect, but you can consider, based upon the objective facts, whether or not it could have had an effect on their deliberations. And that becomes critical in reference to the deprived indifference standard, where the testimony is that that terminology is not utilized at all in the jury instructions, in closing arguments, and opening arguments, at any form of the trial. But you have a situation where after the jury comes back with their first decision, 7-5 for acquittal, then that term is utilized. You have 5 jurors that indicate not only was that term utilized, but it was relied upon. No one could define that term.
Well, Mr. Terry, isn't that impeaching the verdict?
It is permissible impeachment of the verdict because it is extrinsic
It has to do
facts.
with the mental process, doesn't it?
No, because we are not asking, did that affect your vote? What we are telling the court is that look at all the facts. What the facts show is that 2 jurors at a minimum did not change their vote until that terminology was used. And you have to remember,
Doesn't that have to do with the mental process?
it does not have to do with the mental process as far as what the standard is concerned as to what you must look at. You must determine whether or not it exists, and then you must find that it was harmless error beyond a reasonable doubt, not that it had an absolute effect on the jurors. We wish we could have asked that question, but we were not permitted to. At least for purposes of the record, we had requested the right to ask that question, but that was denied us. You have a right to look at the timeline that was provided to the jurors at the end as a memento, so to speak. And the memento says that in essence, the last instruction that they considered was that the death in this case was caused as a result of somebody standing around and watching them die. That's where the term deprived indifference came from. It is not an instruction. It is not anything that was utilized by the court.
And Mr. Terry, you're saying then that there need be no reference to the jurors' affidavits or testimony in order to draw the conclusion that there was misconduct in terms of consideration of law they were never instructed on or misapprehension?
Absolutely, absolutely. And this court has held that way. For example, you remanded a case where it was necessary for an evidentiary hearing where a juror made a decision as to what time period it would make between travel from Carson City to Reno, Nevada. You remanded that for an evidentiary hearing. You reversed the case because a juror said, you know, I know what the weight of these cows are. She took her own personal knowledge and injected that. Never did any juror testify in those cases that it had an effect. But the fact is that it occurred, similar to the California Supreme Court case. You had a situation in this case where the alibi defense was offered, and it was in effect negated because you had a juror that said, and I'm running out of time, the juror that said, you know, I have personal knowledge of this in a business sense. Don't listen to the 3 alibi witnesses. We understand what the paperwork says, but as far as this water meter is concerned, it takes 24 hours to get it. Now that's clearly on point with some of Your Honor's decisions as far as bringing in not what we normally deal with in a day-to-day life, but what should not be permissible because it's a reliance upon someone's own expertise. You have no ability to cross-examine, no confrontation, etc.
Mr. Terry, did the water slip itself say that?
I'm sorry, Your Honor.
Did the water slip itself say that you got applied for 24 hours earlier?
No, it said it was, the testimony was that it was received on that day. That was the testimony. And the testimony was that, depending on which theory of the state's case you believe, the time of death would have been anywhere between 7:30 and 12. The alibi witnesses each testified that Mr. Tabish was present because they were waiting for the water meter. So that was not accurate, Your Honor. I'd like to reserve some time.
May it please the court, my name is Alan Dershowitz, and I'm here on behalf of appellant Sandra Murphy, and I'd like to reserve 5 minutes. I'd like to apologize to the court for my hoarseness of my voice. I have a flu. This is an unusual case in which each of the state's 2 expert witnesses testified in effect that there was a reasonable medical doubt about the other state's witnesses' conclusion concerning the cause of death. Dr. Sims, who performed the autopsy, testified that the cause of death was a combination of heroin and Xanax. Dr. Bodden, the state's other expert witness, quote, categorically rejected that proposition. The state called these witnesses and vouched for them both, and under the law of this jurisdiction, the prosecution cannot ask the fact finder to accept a conclusion regarding a cause of death in a murder case after it has introduced an expert witness who categorically rejects that cause of death. In the leading case of Asbell versus State, the burning bed case, 84 Nevada 345, the prosecution tried to argue death by fire. But the court ruled that, quote, the state who undertook to present the evidence closed the door to death by fire in offering the testimony of Dr. Grayson, who had testified that in his medical opinion, fire had not caused the death. So to here, Dr. Sims' testimony closed the door on the prosecution's Burking theory by creating a reasonable doubt about Dr. Bodden's alleged cause of death, while Dr. Bodden's testimony closed the door on its drug theory by creating a reasonable doubt about Dr. Sims' alleged cause of death. The prosecution told the jury that the 12 of you need not be unanimous as to the cause of death. The judge refused to give the defendant's first requested instruction, which everybody concedes was timely and was reserved and objected to, namely that each juror must agree with each other that the same means or methods alleged in the information was in fact engaged in. If, however, each of you cannot agree with the other jurors that Murphy engaged in the same means and method, then you must find her not guilty. The judge acknowledged that this first request was made in a timely fashion. The court also refused to give the defendant's theory of defense instruction, which exacerbated the problem here. And I think because of the manner by which this case was presented, instructed, argued, this court must assume, for purposes of appellate review, that the jury was not unanimous, and that 6 or some other number less than 12 of them may well have found that the cause of death was not a drug overdose, while 6 of them may have concluded that the cause of death was not suffocation, and any number of them may have concluded that no drugs were forced into the alleged victim. If this is the case, then this is surely the kind of verdict by fragmentation rather than by unanimity that this court and the Supreme Court has condemned. Now, although this court has held, and the Supreme Court has held, that there need not be unanimity in regard to, quote, the preliminary factual issues which underlie the verdict, there must be unanimity in a case, and I'm quoting, where there is a genuine possibility of jury confusion or that a conviction may occur as a result of different jurors concluding that a defendant committed, and here's the key word, conceptually distinct acts. The court in Parker said, we hold that when there is such a danger of a fragmented verdict, the court must instruct the jury on request that if a guilty verdict is returned, a jury must be unanimous on the underlying facts. Now, this is not a case like the one relied on by the prosecution below, and I'm quoting the prosecutor, in which, quote, the poor guy who gets whacked in the head with a tire iron, stabbed in the stomach, shot in the chest, and then thrown out of the airplane, all by the same people. In that case, of course, it's monumentally irrelevant which of the possible causes of death, all of which are criminal and all of which are attributable to the defendants, caused the last breath to be taken. But in this case, 2 of the possible, indeed likely, combinations by which the jury arrived at their guilty verdict produce a non-criminal cause of death in absence of the corpus delicti. If several of the jurors, for example, believe that no drugs were forced into Binion, and several of the jurors thought that the combination of drugs rather than suffocation was the cause of death, the end result could be a verdict which left open the realistic possibility that the cause of death was not criminal at all, or at least that there was a reasonable doubt about whether the cause of death was criminal. Now, it's important, and this is very critical, to note that there was no expert testimony based on the medical findings themselves that if the cause of the death was drugs, as testified to by Dr. Sims, that the drugs were forced on Binion. Dr. Sims agreed that, quote, the medical findings themselves don't suggest homicide. He agreed with that in the preliminary hearing and at the trial. Dr. Sims concluded that the death may have been homicide based entirely on non-medical information. And think about what that non-medical information was. It was information one-sidedly given to him by the private investigator for the Binion family, who was being paid hundreds of thousands of dollars for the investigation. That's what he was given. That's what made him change his mind. Indeed, when he was asked the question at the trial, whether he even knew when he made his determination of homicide that Sheridan had provided 12 balloons of heroin to the deceased on the night before he died, he said no, he didn't know that. The investigator hadn't provided him with that crucial piece of information. And so Dr. Wells, in shifting from cause of death undetermined to cause of death homicide, clearly usurped the jury's function and heard less information in making that determination than the jury was ultimately to hear. But because he's an expert, there is the possibility, I think the likelihood, that the jury may have said, aha, we have an expert opinion that the cause of death was homicide. It was anything but expert. It was not only amateurish, it was wrong, and it was based on inadequate information.
Dershowitz, wouldn't it have been helpful if at trial there had been an objection to the admissibility of the testimony in the first place? It's my understanding that there was a reasonable tactical decision made to allow the witness to testify, and then there was a very, if you look at the end of the final argument in the record, you see a very elegant discussion of the credibility of all of these experts.
You're absolutely right, Your Honor, and we're not making the argument that it was inadmissible. We probably could have. That could have been a plausible argument. The argument's a rather different one, and that is this court, in looking at the evidence in the light most favorable to the verdict winner, cannot conclude that there was expert testimony as to the cause of death being homicide by Dr. Sims. Just as this court could not now say that the government's approach, the government in its brief says our position, it's a very interesting word, our position is, and they said this in the summation, that the cause of death may have been, they called it one possible theory, may have been that they administered the drugs, made him weaker, expected he would die of the drugs, then saw the gardener outside and decided to burk him to speed up the process. There's only one problem. They never submitted that hypothesis to either of their experts. And there's nothing in the record of this case to demonstrate that it is possible to create a cocktail of Xanax, Valium, heroin, make them soluble in water, make them palatable enough to drink. There is simply no expert testimony as to how they conceivably could have got him to drink the drugs. As you know, you can't put drugs in somebody through their mouth when they're dead or unconscious. The swallow reflex has to be in existence. So what they have is a position without any evidence to support it. We think, Your Honor, that the confusing even further, and here I want to pick up a little bit on what my co-counsel said, confusing the matter even further, it seems likely that at least one juror may have concluded that Ted B, having taken Xanax on his own, collapses, then they murdered him by just watching and letting him die, no matter how he ingested the Xanax right after heroin use, depraved indifference. That is in a note. This court simply cannot blink reality. You cannot pretend that that elephant is not in the room. For example, if a note had said there was one juror who was undecided, and the other juror said, well, the defendant is black. We know that blacks commit more crimes than whites. You should vote against him because he's black. Would this court ignore that note? Of course not. And the argument is that it tests the mental processes. There are clearly limits to a court's willingness to blind itself. And when you have a juror saying, this is the way it happened, here is the memento, here is the souvenir, at the very least, the argument has to go as follows. We introduced enough evidence to show it was possible. It's the state that can't now probe the mental processes. The state cannot come back now and say, aha, but maybe they didn't think that way. The objective evidence is that the last vote was cast on the basis of this theory, which is not Nevada law. Indeed, it's not any law.
Didn't the state present expert testimony that he was suffocated?
The state presented Dr. Bodden, who said that as a diagnosis of exclusion, I have concluded alone among the 6 experts, I have concluded that he was burked. Now, of course, if he's burked, it's homicide. There's no doubt about it. You can't burk yourself. There's no doubt about that. The problem is that it was a diagnosis of exclusion. And the state itself, I think if they're pressed, they will have to acknowledge that would not have been sufficient evidence to take this case to the jury. At least they would never have presented this case to the jury. If they would have, why didn't they? They would have had a clear and simple path. Present one witness. They knew that neither witness standing alone was enough. They made their bed, and they have to sleep in it. They could have presented one witness. They could have made this a one-witness case and then try to persuade you on appeal if they won. Unlikely. That Dr. Bodden's testimony, a diagnosis of exclusion, standing against 5 other witnesses, one of whom is the state's own witness.
Well, couldn't the jury decide which one of the witnesses they wanted to believe?
No, Your Honor, not when the state presents 2, not under Asbell. Because under Asbell, the same situation prevailed. You had 2 witnesses, but one doctor presented by the state and vouched for by the state said she could not have died from the flames. This court said that closed the door. The state cannot be in a position of presenting mutually exclusive, contradictory witnesses and then say, ladies and gentlemen of the jury, pick and choose. Pick and choose. When one witness creates a reasonable doubt about the other witness and the other witness creates a reasonable doubt about the first witness. That is a reasonable doubt. The risks are simply too high that this defendant was convicted in this case on the basis of insufficient evidence for this court to be able to affirm this verdict. Now, Your Honor, the other crucial piece of evidence that was submitted, and it was a dynamite piece of evidence. If I were a prosecutor, you'd die for this piece of evidence. The decedent, on the night before he dies, says to his lawyer that if I'm dead, you'll know what happened. Take Sandy out of the will if she doesn't kill me tonight. The state has the unbelievable arrogance to argue to this court that it used that evidence only to show the state of mind of the decedent and that it was not trying to prove that the decedent believed that Murphy intended to kill him. They acknowledge that if that's the way they used it, it would be an improper use. You can't use hearsay to prove the state of mind of somebody else. And now just listen to the closing argument and conclude whether you believe that they used it in this way. Here's the closing argument. Take Sandy out of the will. If she doesn't kill me tonight, if I'm dead, you'll know what happened. This is the prosecutor. Truer words were never spoken. In other words, taken for its truth, not state of mind. Truer words were never spoken. Less than 24 hours later, Ted Binion was murdered in his house. He was murdered by people that presumably he trusted. He was murdered by his former girlfriend and his newfound lover. Let them explain to you how this statement, which was the apex of their closing argument, deals with his state of mind, the victim's, rather than clearly a prediction like in the Shepard case, she's gonna kill me. That's the way they used it.
Didn't the defense set forth the theory of suicide?
Yes, and it could, and we concede right here today.
Didn't the state have to offset that?
Right, but it can't use it this way. It can use it to say, here's what it could say. It could say, first of all, it has to first overcome a burden. Just because you introduce suicide doesn't mean the state can introduce any hearsay statement. It has to show that the statement is inconsistent with a suicidal state of mind. It's not. Guy comes and says, my girlfriend is going to kill me. She hates me. Take her out of my will. Who knows? I might be dead tomorrow. That doesn't sound inconsistent with suicide. That sounds consistent with suicide. But if you believe that the state really introduced it only for that reason, then you must challenge them. Why did they use it in this fashion? Why did they use it to show it was a prediction that was going to come true? Even if it's true that they had a narrow basis for introducing it, they clearly misused it, and the judge should have seen that coming, as they were told to see it coming in the preliminary. There was a whole colloquy, 5 pages, in which this distinction was drawn. And yet there was no limiting instruction, there was no attempt to try to show that it couldn't be used in that manner, and the government exploited that ruling and exploited it in a way that was utterly unfair. They exploited something else, Your Honor, the severance issue. Remember that the courts had held that Sandra Murphy could not be tried on the matter of Casey. She could not be tried on it. Nonetheless, they kept her in the trial and they kept Casey in the trial. Now the judge made a ruling. He tried to split the baby in half. He said, you cannot use any evidence about Casey in respect to Murphy. But that's impossible. The only reason the Casey material was introduced in this case was to show a motive for the murder. Who committed the murder in the state's view? Not Mr. Tabish alone, but Tabish and Murphy. How can you conceivably introduce evidence about a motive that Tabish has which doesn't also impact on the other defendant? In this case, repeatedly, in arguing the Casey matter. Just look at the brief. Look at the briefs in front of you, Your Honor. Take one more minute at my rebuttal time. The briefs in front of you in the Murphy case start with 10-page discussion of the Wells case. Inadmissible, and yet 10 pages to you about the Wells case. 20 pages in the closing argument to the jury. Starts out with Wells. Wells is the motive. Wells is the motive. You can't have Wells being the motive. Wells is the motive operandi. Wells is the commonality. When you have 2 rulings, one that says you can have the trial together, and the other that says you cannot, however, use the evidence against one of the defendants, then it's impossible to make the arguments that you make for joinder. You can't say cross-admissibility. That's one of the key words, cross-admissibility. The evidence isn't cross-admissible. The judge said it's not admissible against Murphy. You can't say common plan. If it was common plan, it would be admissible against Murphy. The fact that none of the evidence is admissible against Murphy proves conclusively that there is a logical and legal impossibility of trying this case together, that is, trying the Casey case together and saying you can use it against Tabish, but you can't use it against Murphy. Your Honor, for these reasons, we would request reversal, and I'd like to reserve the rest of my time for rebuttal. Thank you very much.
State of Nevada.
May it please the court, David Wall on behalf of the District Attorney's Office. I will be using roughly half of the time. I think the light's going to come on after 20 of our 40 minutes, and I will be addressing those issues raised by Mr. Dershowitz on behalf of Sandra Murphy. Mr. Roger will be addressing those issues raised by Mr. Terry and in the briefs as to Mr. Tabish. As undoubtedly often happens before this court, the legal issues are framed by the facts. When you set out to make murder look like something else, whether it's an overdose or suicide, to hide the crime by disguising the means, then it helps crystallize the issue when you come before this court and say the manner and cause of death was unclear to those who examined the scene. The issue with respect to the conflict in the medical testimony, that there was no proof of death by criminal agency. The standard is, from this court, whether viewing the evidence in the light most favorable to the state, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt, even where the evidence is circumstantial in nature. The briefs on behalf of Ms. Murphy spend quite a bit of time assailing the credibility of Dr. Bodden, not so much based upon his testimony, but about his background. They trumpet the credibility of their own expert witnesses, calling them at one point, I believe it was unimpeachable and unimpeached, both of which the state would disagree with. The credibility of conflicting expert witnesses is for the trier of fact. It always is. There's always experts on the other side who disagree.
But these experts were presented by the state. Both of them were presented by the state with apparently inconsistent theories.
Correct.
Did our Aspill's case say that that's improper?
You know, Bill, as you recall, was the woman who was probably drugged, or at least that was part of the theory, in her bed, and then the bed was set on fire by the defendant. And there was no question but that he had set the fire. There were witnesses. This court said in Asbill that the state need not eliminate all non-criminal explanations, but there must be an inference of death by criminal agency. The victim in that case may have had the mixture of alcohol and barbiturates in her. I think she did. The medical examiners found no evidence of death by strangulation or suffocation, and no evidence, none, that she died as the result of the fire. There was no evidence within her lungs that she had inhaled any smoke or any of the accelerants or anything to suggest that she was killed that way, that the fire killed her. Where there is no plausible theory, then of course there is no showing of criminal agency. In this case, whether they...
Is Asbill a case that holds that there is just simply no evidence of a criminal agency introduced, notwithstanding the evidence of what ordinarily would have caused the death, that is the fire?
Right.
In Asbill, clearly there was no evidence of any lung damage.
And it appears that...
Is that what that case holds, or does that case holds that once you have introduced as the state expert evidence of non-criminal agency, that you are then, as a matter of law, foreclosed from establishing criminal agency through other means?
The former, not the latter, Justice Bopp. And in fact, what they almost chided the prosecutor in this case, this court did, and said, you know, if you wouldn't have stuck to your theory that she was burned, you know, we might have said that there was evidence of criminal agency. But the prosecutor refused to do that, went forward with his statement that there was death by fire in this case, and when there was no plausible evidence to support that, then in fact there is no evidence of criminal agency. And I think that case actually came up here on a writ after presentation to the grand jury, where there is no plausible evidence of a theory of criminal agency, then yes, it is correct that that case should not go forward. In this case, even if there is a conflict between the two, you know, I'll be honest with you, like the example we used in closing argument and the example that the Supreme Court of the United States used in Shad and some of the other cases, where it's not abundantly clear exactly how they killed him, you can present each of those theories to a jury as long as they both conclude it's homicide, as long as jury concludes that there is no doubt, or beyond a reasonable doubt, that the defendants were responsible and that the defendant murdered the individual, that's enough. And that's where the whole unanimity issue comes in. Understand that the whole process by which they killed him was to make him look as though he had died by other means, whether it was overdose or suicide, whether you want to call it accident or not. And when we look at Asbill, and even when we look at Frutiger, those decisions talk about no evidence of criminal agency, and they talk about the difference, the four manners of death: accident, homicide, suicide, or natural causes. And what we had in this case, and what we have in every case, is you have a medical examiner who determines what the actual physiological cause of death may be, and then turns to the issue of the manner of death. And the issue of manner of death always includes the surrounding circumstances of which he becomes aware. Because...
Mr. Wall, if you had a question as to what caused the death, why didn't you prosecute Peter Sheridan? He's the one that furnished the heroin the day before. You had a criminal agency there.
Because there's an intervening, superseding cause of the death, and that is the suffocation by Tabish and Murphy, or at least the use of the drugs to put him in a position where he could be easily suffocated by Tabish and Murphy. The providing of the drugs, first of all, didn't in and of itself cause the death. Perhaps under Morris, under a second-degree felony murder rule, it's possible to make that attenuated connection, but we didn't feel it was appropriate.
Well, your cause of death could have been an overdose, or it could have been suffocation.
You mean an intentional overdose by the defendants?
Your expert testified there wasn't enough heroin for an overdose, so he must have been suffocated.
And the drugs may have eventually killed him, but it was our theory in closing argument that there was in fact suffocation, as reflected by Dr. Bodden, that actually killed him. And with that being the intervening superseding cause, then Mr. Sheridan wouldn't have been available.
So your theory wasn't that this was a forced overdose?
It was
that there was an overdose, however, it occurred, and then it was strangulation under Dr. Bodden's theory.
Suffocation, correct.
Suffocation.
That whether he took some of those himself or all of those drugs himself, or whether they were given to him in the cocktail for which Ms. Murphy was alleged to have stolen the glass the following day, that it was ultimately the suffocation, those drugs, whether intentionally ingested or ingested with some help from the defendants, put him in a position, I think the word used by the experts was obtunded. He was obtunded, he was made more accessible to suffocate because he was less likely to be able to respond, to be able to fight back, especially as the evidence reflected when restrained about the wrists.
So you decided not to prosecute the drug dealer?
That's correct. It would have also been that the only witness available for that would have been Sandra Murphy, whom we felt was obviously the intervening superseding cause, along with Mr. Tabish, in the suffocation death of Mr. Binion.
So then Dr. Bodden was essential to your attempt to establish criminal agency?
I would say that we certainly rode that theory, that he suffocated, because it was the only theory that took into account all the marks on Mr. Binion's body.
That being the case, could you then reiterate why it is that under Asbill, Mr. Dershowitz has maybe overanalyzed that case?
When he says that if you take one theory and that closes the door to the others, that's not correct. What Asbill tells us is that as long as there is evidence of death by criminal agency and an inference thereof, because I think Asbill came up on the inference from the grand jury proceedings on a writ, that's enough, that even if the experts disagree as to exactly how the defendants killed an individual, that doesn't in and of itself indicate that there's no criminal agency, and that doesn't close the door from one expert to another.
But why isn't Mr. Dershowitz's argument that that's a logical extension of Asbill apply here?
Because, for one thing, we can't always tell how defendants kill their victims. Now, this court has upheld several decisions, I think, where no body was ever found. The Weeks case and perhaps the Vignolo case are cases in which there's no question. The way we argued it in closing argument, that if that person, and in fact, if you take what the United States Supreme Court said in Shad, where there's, I think it was Justice Scalia's concurring opinion, where he says, "It has long been the general rule that when a single crime can be committed in various ways, jurors need not agree upon the mode of commission. When a woman's charred body has been found in a burned house and there is ample evidence that the defendant set out to kill her, it would be absurd to set him free because 6 jurors believe he strangled her to death and caused the fire accidentally in his hasty escape, while 6 others believed that he left her unconscious and set the fire to kill her." So even if the experts in that hypothetical case that Justice Scalia gives us had testified that way, one that she was strangled, one that we thought the fire killed her, that wouldn't absolve the defendants of criminal liability. It doesn't say that one expert is closed by the state as opposed to the jury accepting both of those and determining in their own minds as the triers of fact how death was occasioned.
In this case, you had evidence of an overdose.
Yes, we did. We had evidence of Xanax and heroin in his system. Dr. Bodden.
Enough to kill him.
Well, that's unclear. Dr.
Well, that's
Bodden
where the experts differed.
Yes.
One expert said it wasn't enough, and the other expert said it was enough to kill him.
Because there's no real dead cutoff point after which it is a lethal dose. There are lethal doses down here, and there's lethal doses up here of both the heroin and the Xanax.
Wouldn't it have been easier to prove criminal agency regarding the drug dealer?
To prove Because it was our theory that, in fact...
One of your problems is you're having trouble proving criminal agency here.
Right.
And you wouldn't have had that problem with the drug dealer.
But it was our position and our belief all along that Mr. Binion was suffocated. And that the marks on his body were caused by that, which was the intervening, superseding cause from what Mr. Sheridan did the night before when he provided the heroin and the pills.
Out of expert witnesses, how many agreed with your theory of suffocation? How many expert witnesses were there?
Dr. Bodden was the only one. Obviously, none of the defense experts indicated that Mr. Binion was suffocated. But they did indicate certain of the items that led Dr. Bodden to that conclusion. Dr. Rawson, Senator Rawson, who nowhere appears in the appellant's briefs, nor did he appear in their closing argument, testified, as did Dr. Bodden, before Dr. Bodden, that the small round marks on Mr. Binion's chest were the result of his shirt buttons and pressure as a result of those. No one else did that. That supported Dr. Bodden's theory. Dr. Rawson testified that the marks on the wrist were made by the same type of instrument, and there's a mark on the left wrist and a mark on the right wrist, consistent with Dr. Bodden's theory. Dr. Rawson also testified that the marks around the mouth, the redness and the abrasions around the mouth, could have been the result of sustained pressure upon the mouth, as in roughly performed CPR, consistent with Dr. Bodden's theory. Dr. Buckland, on behalf of the defense, indicated that the marks on his face, his chest, his wrists, and his knee were in what he called the agonal period, 10 minutes before to 10 minutes after death, consistent with Dr. Bodden. The problem was with
Justice Young's questions, how many experts testified the overdose was the cause of death?
Probably in addition to Dr. Sims, Dr. Snyder indicated that there was enough on drugs in him to kill him. Dr. Wecht did, although he went further and said that it was suicide. And Dr. Buckland said that he thought that it was inconclusive. That he couldn't say it was homicide, suicide.
So there's only
accident.
one expert that said it was suffocation. The other expert said it was overdose.
Right.
Did the one expert testify or reach his conclusion after the investigation by the private investigator?
He was contacted originally by a representative of the estate of Ted Binion. He originally came with a diagnosis that the drugs, the Xanax, had killed Mr. Binion. What had happened was the actual computer-generated toxicology report from the lab in Las Vegas was sent to individuals, among them Dr. Ellen Clark from Reno, who reviewed that, and her office retyped the calculations of the amount of drugs in Mr. Binion's body. That retyping contained an error. Instead of saying that there was X number of nanograms per milliliter, I believe in the blood or in the stomach contents of Mr. Binion of Xanax, it said milligrams, 1,000,000 times more Xanax. That's the report that was originally furnished to Dr. Bodden, and with that much, 1,000,000 times more Xanax, his original conclusion was the same as Dr. Sims. When he came out to Las Vegas, reviewed the original lab report from Las Vegas and saw that it was nanograms, looked at the photographs, including the Polaroids that the actual medical examiner's office had seen, looked at the tissue samples, including an area of hemorrhage along the rib cage underneath, consistent with where the pressure was placed on Mr. Binion's chest. When he looked at all of those, when he went to the home, when he did all of that investigation and took all of the marks on his body into consideration, that's when he changed his theory. I mean,
that was after he received the report from the investigator from the estate?
He received, I don't know that he necessarily received a report from the investigator. He may have received some of the documents that were provided, some of the photos and things like that, but I'm not certain that, I don't think that he received a particular report. And understand that at that point, I mean, it was not exactly consistent with what the accepted theory of Dr. Sims was. You have an expert on behalf of the estate coming in and saying, look, you can, you know, I disagree with Dr. Sims' conclusions. Here's my theory, and here's why. And when it was obviously the jury, because they did remove the deadly weapon enhancement when they convicted of murder, the instructions said that the substances, Xanax or heroin, could be a deadly weapon under 193-165 that defines what a deadly weapon can be. They returned verdicts of murder in the first degree without the use of a deadly weapon, suggesting, I think, that the suffocation angle, the only one that took into account all the marks on Mr. Binion's body, was the one that they accepted.
Mr.
Before
Wall,
the excuse me.
I was just going to ask, you put great weight, and apparently the jury did too, in Dr. Baden's testimony, but he reached the conclusion that this was not, could not be an overdose. But then he admitted in cross-examination that he was basing his opinion on East Coast heroin that he was familiar with, and not West Coast black tar heroin that we're dealing with in this case. And that's much stronger. Doesn't that knock the underpinnings of his opinion out completely? And why is his testimony in any way reliable when he was talking about making his opinion on one type of heroin, and we're dealing with another type of heroin here in this case?
I know that there was some cross-examination regarding the East Coast heroin. He testified that it was, in great detail, as I recall, on direct and perhaps also on cross, that it was black tar heroin, that essentially that he is the overwhelming and perhaps undisputed expert on heroin deaths, that he has studied this form called chasing the dragon, which is used with black tar heroin in New York. He's been to the Far East in Hong Kong, where it first began, which is where the chasing the dragon phrase comes from. That he had studied all of that literature, that he had been there, and that he had never heard of a single heroin overdose death through the use of chasing the dragon. So I don't specifically recall, Justice Rose, him saying that this was a different kind of heroin. This was Mexican tar heroin, as I recall the testimony that came up, and something that he indicated that he was familiar with.
Our staff just indicated that he admitted that he based his conclusions on the effects of East Coast heroin, and we'll certainly check the record too.
Yeah, because I know there was extensive discussion when we talked about chasing the dragon as to what that phrase meant, what his expertise was in heroin-related deaths, and where that came from. And I know he testified about having been back east. The Shad case, and that I know the court is familiar with, I think is essentially dispositive. In fact, they not only deal with the issue of unanimity that this court has dealt with before in terms of the theory of first-degree murder, whether by felony murder or by premeditation, but also they discuss the issue of unanimity as to cause of death, not only in the concurring opinion from Chief Justice Maupin, no, I'm sorry, Chief Justice Maupin, almost, Scalia, as well as in the plurality opinion, when they discuss by analogy a murder committed by one of two means, shooting and drowning. They go back to the Anderson case, 1898, where the individual was shot with a musket, I think, and thrown overboard into the ocean. And there was no necessity to try to prove that the shotgun blast or the drowning actually killed him, just that the individuals involved were responsible for his death. And that's exactly what we have in this case. I'd like to defer to Mr. Roger for the remaining time, if we could, unless there's...
Mr. Wall, thank you very much. Mr. Roger, on behalf of the state of Nevada.
Good morning, Chief Justice Maupin, members of the court. My name is David Roger. I'm one of the trial attorneys. I'd like to address the allegation of juror misconduct. With great respect to Mr. Terry, I have a little different opinion on the law as it relates to getting into the thought processes of the jury. Back as early as 1785, Lord Mansfield opined that we should stay out of the jury deliberation room, that we should instruct the jury, give them the facts, and then once they go into the jury deliberation room, we should stay out of it. There have been exceptions. The federal rules of evidence have codified some of the exceptions. This court has carved out two very limited exceptions to that rule. One exception is when jurors are not candid during voir dire and they hide certain biases. Then we can go back and consider their lack of candor during the voir dire process. And then the only other exception that this court has carved out is when there has been something that has invaded the jury process. Independent research, whether it's going out and looking at statutes, dictionaries, whether it's going out and conducting tests on their own outside of jury deliberation room. It's only under those two exceptions that this court has allowed judges and lawyers to invade the province of the jury. You have had cases that have come before you, Rybell, where a jury said that they only voted a certain way because they felt that the judge would show leniency to the defendant during the sentencing phase. You were asked to review a capital murder case at Echeverria, where Echeverria was charged with shooting and killing an FBI agent. He was sentenced to death, and the jury came back and said that they only voted for guilt because they thought that because of jury misconduct, the verdict would have been overturned on appeal. And you rejected both those cases, those allegations of jury misconduct, because it was the thought process. While the defense condemns the jury, so to speak, in this case, and Mr. Wall and I tip our hats to them, they sat in on about 6 weeks of trial time. They listened to 105 witnesses. They examined close to 400 exhibits in this case. They listened to 3 days of closing arguments. They considered 70 jury instructions. They went back into the jury deliberation room and they did the very best that they could. All that we can ask of a jury. When they had questions of fact, they came back to the court and asked for readbacks. During the jury deliberations, they had a question about the maid's testimony. So we had a readback, and they went back into the jury deliberation room. When they had questions of law, they came to the trial court and asked for clarification. They had a question about the kidnapping charge. So we came back into the courtroom, the judge instructed them on kidnapping, and they went back and deliberated some more.
How do you justify the depraved indifference? That's a question of law, not a question of fact.
Not according to the facts, Justice. The evidence that was presented was that it was not independent research. It was a saying that one of the jurors talked about. That's it. There was no evidence that they went out.
They didn't ask the judge to explain that.
Oh, well, according to them, it wasn't part of their deliberation process. It was not. They did not consider.
If we cannot consider their statements in determining the defense's argument about what took place in the juror's mind, then neither can we consider the evidence that they didn't consider it.
You're absolutely.
The issue is that one of the jurors brought in a summary of the jury instructions based upon his or her understanding. And in that summary, there was a concept of depraved indifference, which is not one of the instructions on the law in this case. So how does that objective fact affect the validity of the verdict?
Justice Becker, I think that that's not entirely correct. What they did, as far as the instructions, the summary, was that one of the jurors went back and created an index of all 70 instructions so that what they could do is say, okay, we want to look at the reasonable doubt instruction. And they would go to the index and say that, find that that instruction is number 56. There was no instruction, there was no summary of an instruction that talked about depraved indifference. That was something that one of the jurors mentioned on day 5. It was not a matter of legal research. It was not a matter of going to a dictionary and coming up with that.
I thought the juror said he heard the phrase on television. He thought that was all right, that they stood by and let this person die, that that's enough for murder.
No, that juror said that she thought that she had heard depraved indifference on a TV show, but that was it.
Well, what
if they had
did
come
that
up
have on the jury? In other words, did they convict them because of depraved indifference?
Well, it goes back to the thought processes of the jury, sir.
This is not a fact. This is a question of law.
No, I disagree. This is something that someone brought up. It was a statement
It was a
that was
theory
made.
of law that they could convict them on.
That's the defense's position, that it was a theory of law. None of the jurors ever testified that it was a theory of law. It is the defense who says...
Did they taint the jury?
If it is not something that comes, legal research, that comes from outside of the jury room, then we can't get into it. Now, Judge Bonaventure considered the issue that you're talking about. Our position was that it went to the thought processes of the jury and that we should not have this hearing. But Judge Bonaventure, who held an extensive hearing and listened to all the facts, concluded that it did not prejudice the defense. And I think that we should give some deference to Judge Bonaventure's decision. You know, we talk about some of these things and these claims of alleged misconduct, and the defense tells you that it's cumulative error. Well, when you take a look at some of these issues, with great deference, with great respect to my colleagues, it's silliness. If for example, extrinsic document witnesses, if the jurors had gone to the big blackboard that we have in the jury deliberation room and numbered 1 through 105, the witnesses who testified, would that be misconduct? But instead, he writes it on a piece of paper and they consider it in their deliberations. All of a sudden, it's misconduct. The same thing with the summary of the charges, the summary of the instructions. They could have gone to the blackboard and listed all of these instructions. How then would they be claiming that it's misconduct? That they talk about improper communication with the bailiff. We learned that on day 3 of deliberations, the bailiff had a conversation with the jury foreman in the parking garage. And there's perhaps a misunderstanding as to what each person was thinking. The jury foreperson said that he thought that the bailiff was asking about their deliberations, how they were doing in their deliberations. The bailiff said he only intended to ask about how they were doing. The fact remains that they continued deliberating 5 more days. How is that prejudicial to this jury's verdict? It isn't. Justice Rosa, you asked the question about whether or not this water meter, whether the waiting period was listed on the water meter receipt, and it was.
That's what I thought.
So how is that prejudicial to the defense? You see, they pick and choose on what facts they feel are important in this case. They pick and choose which facts they believe swayed a jury one way or another. That's exactly what we should stay away from, with due respect to the court. They neglect.
I'm sorry. There's been an argument that we should adopt the reasonable possibility that it could affect the jury from the Ninth Circuit's cases. Do you agree that that's the appropriate standard? And if not, what standard do you think applies if we find that there is any jury misconduct?
I believe that there was no misconduct, that all of this is the thought processes of the jury. I believe that this should be stricken from consideration.
That, but assuming that we do not agree with you, then what standard do we apply to determine whether or not this constitutes reversible error? Is it a reasonable possibility it could affect the verdict, or is some other standard appropriate?
I don't think it should be a reasonable possibility. I think that perhaps a harmless error might be appropriate. I'd have to rely on our briefs as far as that issue is concerned. But going back to the water meter receipt, the defense claims that ruined their alibi. Well, what ruined their alibi from our perspective was the fact that we had witnesses, a witness who came in to testify that Mr. Tabish had solicited him to pay off alibi witnesses. We had a written script that Mr. Tabish wrote that he gave this person, telling these witnesses what to say during their alibi testimony. We have evidence that Mr. Tabish hired a person by the name of Ishma to go out and create false evidence in the case. So when the defense says that allegedly extrinsic evidence came in and it affected their case, I disagree. But ultimately, it's up to the jury to decide. They talk about this Palm Pilot. This is another invasion of the jury. And I understand why the judge did it, but we took this Palm Pilot away from the juror after the trial, and we had a computer expert analyze the contents of this Palm Pilot to make sure that there were no email messages back and forth from a juror and someone else talking about this case. We went to great lengths to make sure that these defendants received a fair trial. So he utilized the Palm Pilot for a calculator. Well, couldn't he have gone to this blackboard in the jury deliberation room and gone through the mathematics? How is that prejudicial to the defense?
Did you also use it to verify an airline telephone number?
Yes, Your Honor.
So it wasn't just simple arithmetic. He used it to verify evidence that had been received in the case to test its reasonableness.
Correct, and I was going to get that. But however, that phone number was in evidence. It was on a document, and one of the jurors said that they later found that document. They found the number for Delta Airlines. He also used it.
So the jury's instructed that they're not to refer to any outside sources in considering their decision. And referring to an outside source to verify a phone number, because perhaps there was doubt as to the evidence that had been received, is referring to an outside source. It is a violation of their instruction on deliberation.
Justice Agassi, let me tell you, I would love for us to have perfect trials. I don't necessarily enjoy 8 weeks of trial and then having to, deal with this particular issue. But the point is that there was no prejudice because...
Okay, so you're arguing this is a matter of harmless error?
Yes. In addition to that, they used the Palm Pilot as a calendar. But in evidence, we had a calendar. The defense introduced a calendar. So where's the prejudice? You see, when we're talking about this jury misconduct, much of it is the thought processes of the jury. And others have established that there is no prejudice to the defense in this case.
Mr. Rogers, I don't want to eat into your time, but there is an issue that I'd be very interested in hearing you address on the issue of prejudice, and that is the decision that the trial judge made at the behest of the state to include the Casey matter with the Binion matter.
Yes. As you know, joinder severance is left to the sound discretion of the court, and the standard is whether there is an abuse of discretion. We charged conspiracy to commit robbery and or murder as count 1, and that conspiracy started, I think the date was March of 1998, and continued on past the murder of Ted Binion.
And the conspiracy is between Tabish and Murphy?
Yes.
And the Casey case was not to be used against Murphy?
Correct. The statute talks about events that are connected together. In this case, we had Rick Tabish, who was in desperate need of money. The IRS was after him for about $900,000. He had loans. He was in desperate need of money, and he had this opportunity that he created on his own to get this Gene sand pit, which was worth at least $10 million, if not more. He took Leo Casey out into the desert. He beat him. He extorted his interest away from him, so that Tabish, prior to Ted Binion's death, had this interest in the sand pit, but he needed money in the worst way. He needed money to be able to extract this sand, and therefore...
How does that affect Sandy Murphy? Isn't that prejudicial as to her to bring that count in on the case?
Oh, well, she was involved in the murder, and the murder was for them to get money to have this sand pit and live happily ever after.
So you're saying that she was involved in the murder in order to get Tabish some money to get the sand pit?
Justice Leavitt, when you as a trial judge try cases, there are many times when people aren't involved in certain counts. But because of judicial economy, because we are able to...
Is that prejudicial to Sandy Murphy to bring that in?
There may be some...
inference, in other words, that she murdered him to help Tabish get the money to buy the sand pit.
There is always a balance that we use in the law.
Well, part of that balance includes judicial economy, which I'm interested in, because there was a separate trial in any event with respect to Casey.
But Casey was also a witness in the murder case because Rick Tabish had made comments to him about how he was going to murder Ted Binion.
How was there judicial economy in including the Casey charges with the Binion charges?
Because we would have had to have tried two separate cases. We would have had to have put on the Casey incident as well as the silver theft and perhaps even the murder, because the murder was one of the motives.
But there was a separate trial for Casey with respect to Tabish's co-defendants, yes?
No. No. The judge, we stipulated to a severance of those other defendants, but those defendants never went to trial. The same can be said for the silver theft individuals. Judge Bonaventure exercised his discretion and granted their motion to sever. But there was no separate trial there. But in addition,
was the case against the Casey co-defendant still pending as of the commencement of the trial against Mr. Tabish and Ms. Murphy?
Yes, sir. But Justice Agosti, Justice Leavitt, Judge Bonaventure went to great lengths to ensure that Ms. Murphy's prejudice was very limited. Before certain witnesses testified, Judge Bonaventure instructed the jury that they are not to consider that evidence against Ms. Murphy. During jury instructions, there was a separate instruction that told the jurors that they are not to consider that evidence against Ms. Murphy.
And as I understand your theory, you would have, had the judge severed the charge, you would have offered this as evidence of a prior bad act against Tabish in any event.
Yes, because the motive for Ted Binion's murder was to get money for the sand pit. And so it would be cross-admissible. But Judge Bonaventure went to great lengths to ensure that any prejudice was minimal when it came to Ms. Murphy.
So the evidence was to be considered by the jury against Tabish and for the purpose of establishing motive.
I don't believe, well, I mean, that was our purpose, yes.
Okay. I'm sorry.
Thank you so
How would
much.
it then be cross-admissible against Murphy if you had tried Murphy separately? If Judge Bonaventure ruled it couldn't be used against Murphy, then in a separate trial with her, it wouldn't have been admissible in her trial.
We never got to that point where we made that motion. We had originally charged Ms. Murphy with the extortion as well, and Judge Bonaventure found that there was insufficient evidence. In closing, members of the court, Rick Tabish and Sandra Murphy may not have had a perfect trial, but they certainly had a fair trial within the meaning of our Constitution. Thank you.
Thank you, Mr. Roger. Mr. Terry, and rebuttal.
Ms. Murphy and Mr. Tabish did not have a fair trial. And I'll address myself first to the issue of the joinder versus the severance. Counsel for the state is hard-pressed to acknowledge to this court why they would have conceded that a severance was appropriate for the co-defendants in the Casey counts and not appropriate for Mr. Tabish to divide the murder case from what are commonly referred to as the Casey counts. There was going to be another trial. It is merely a fortuitous fact that each of the defendants who had already been severed entered pleas of guilty after the adjudications of guilt by the jury in the Tabish and Murphy case. You can't sidestep that. The state stipulated to the severance. Your honors have decided cases where individuals have been charged with sales of a controlled substance, and merely because they're charged with 2 counts of sales of a controlled substance, that does not mean in and of itself that those matters are properly joined. The district attorney's approach recently, and I would suggest if this case is a good example of that, is to take a case that is not properly joined in the first place and join it. Thus, the burden becomes on the defendant to move to sever it, as opposed to take 2 cases which appropriately should not be joined, and they have to move to consolidate those. The burden has shifted to the defense. It is inappropriate, and the actions of the state in not acknowledging that the severance should have been granted in this case are well demonstrated. Justice Becker has asked the question whether or not this court should adopt the Ninth Circuit view as to reasonable possibility. If you do adopt that view, this case is clear that it must be remanded back for purposes of a new trial. But I would suggest to you, even if you use the harmless error approach and the 5 factors set forth in the Huey case, which you have already decided, that the answer is still going to be the same. Mr. Rogers indicates that some of the things which we have raised are mere silliness. We don't raise mere silliness when we are concerned that a judge is allowing a bailiff to have conversations with a jury to such an extent as allowing them to have partial jury instructions. Why wasn't the state notified of that? Why wasn't the jury, the defense notified of that? Is that silliness when you have a statute that mandates it? Is it silliness when the normal procedure is to advise both the state and the defense? Is it silliness because we are concerned that the jury, when they take a look at these made-up jury instructions, they utilize a term shadow of a doubt? And we understand the state's position, that's a tougher standard, but that's not reality. What this court has said is you cannot deviate from the reasonable doubt instruction. It's codified under the Nevada Revised Statutes, and additionally in Petrocelli, in Collins, in Byford. You've told us time and time again, Don't deviate from this. And that's exactly what was sanctioned in this case. Please look at the timeline. We understand and we suggest to the court that the term depraved indifference is a factor of law, not a factor of fact. If you analogize this with the previously cited case from California, there is no doubt that it must be remanded. But look at the timeline, look at the effect. Those are objective facts which you are allowed to look at. The first vote 7-5, the second vote 1, and 10. But look on your diagram as to what's being discussed at this point in time. The term is bandied around in the jury room. This is not one juror, unlike the Dershowitz case. This is not one juror that starts to talk about this term. It is a multiplicity of jurors. Look at the fact that...
It's your theory that it's a question of law, not a question of fact.
That is correct.
The state says it's a question of fact in the mental process.
They have to say that because the law is much more clearer if it's a question of law, like a definition of robbery. If you're wrong on a definition of robbery, it's much more clearer. If you're wrong on a definition of fact, then the standard is somewhat different. But if you look at the chronology, and if you look, and it's interesting, Mr. Wall says in his address to you, well, the jury never came back with use of a deadly weapon. I would suggest to you that objectively, what that also shows is exactly what we're suggesting, is that objectively, what that jury ultimately convicted for was exactly what's in the depraved indifference timeline, which is somebody stood around and watched him die. That's why you don't have a with use of a deadly weapon provision. The only other theory that you could adopt is the only other one that the state has argued, which is that he must have died by mere suffocation. But if you look at the commemorative document that was given to all the jurors, which again is an objective fact that you could consider as to how they arrived at their decision, the terminology that is utilized is, it wasn't suffocation, stood around and watched him die. Thank you for your consideration.
Very much, Mr. Terry. Mr. Dershowitz in rebuttal on behalf of Ms. Murphy.
Thank you very much. Your Honors, Mr. Wall made a remarkable concession in his argument that I really want to focus the court's attention on, because that concession alone, standing by itself, requires a new trial here. He conceded in response to a question by Judge Leavitt, when you asked, were there enough drugs to kill him, his answer was, that's unclear. Then he said, it's been our opinion all along that the cause of death was suffocation, not a drug overdose. If that's true, this whole issue need never have been before this court. All the government had to do was to say to the jury, in order to convict, you must find suffocation and burking. Why did the government offer the jury an option of finding death by drug overdose when it concedes that there is insufficient evidence of a drug overdose? In this court, it has said it is unclear. In this court, it has said it is their position he did not die of a drug overdose. And yet, he allowed the jury to conclude that he did die of a drug overdose. He is bound, the state is bound by that concession. I would be prepared, Your Honors, even to give him time to respond to that. This is such an important issue. If it is true that it's been their position all along that he did not die of a drug overdose, this whole case has been wasting this court's time. All that was necessary was to charge him, to bite the bullet and charge him and say, our theory is that he died of burking and suffocation. Then you'd have had one witness saying that, 6 witnesses saying the other. Either there'd been an acquittal, which seems very likely, or the case would not be up here now on whether you need unanimity. The state made a tragic mistake. It should have conceded the objection and said, yes, there should be unanimity, and the unanimity must be on the burking. That's our theory. They can't come up to this court now and change their mind and say, whoops, we're sorry. We now know that there was insufficient evidence on the drug theory. That's what they're saying. It's unambiguous. There's no doubt about it. I heard it. I wrote it down. They can't escape that concession. If that concession is binding on them, then this case never should have gone to the jury on two alternative theories. It should have gone only on the Birking theory. I don't think I have anything further to say, Your Honors. It seems to me this is so clear. Except I would ask the court for permission to file an application for bail pending appeal for Appellant Murphy. She was out on appeal for most of the pretrial. If there's any possibility, and we think there is a significant possibility, certainly based on this concession, that there may have to be a new trial, the appropriate course would be to return to the status quo and allow Ms. Murphy to be out on bail. She has been a superb prisoner. She is not a risk of any kind. She is determined to validate her innocence, and so I would ask this court to consider the possibility of releasing her on bail pending appeal. Thank you very much.
May I ask
yes, please.
the counsel one more question? You didn't comment in your reply on the severance argument that was made by the state.
I'd be happy to do it.
I would like to hear your response to their position that this was a course in a scheme and that the failure to severance was proper.
Well, first of all, the judge ruled it was not a course or scheme, because if it were a course or a scheme, of course the evidence would be admissible against Sandra Murphy. The fact is, the most they could ever argue is that if there had been separate trials, say separate trials of Tabish, let's put that for a moment, a separate trial on the Wells matter and a separate trial on the murder. On the murder, only a small number of items of Casey would have come in. For example, yes, we admit, the item, I admit, I can't admit it on behalf of my fellow defendant, but it seems to me logical that if he admitted he was going to kill Tabish, that would come in. But the gruesome nature of the extortion, the thumb thing, finding a thumb constraint in Murphy's bedroom, all of that comes in against Murphy. And once you have a ruling by the judge, Your Honor, that nothing from this case comes in against Murphy, then it seems to me the only logical way to proceed is to have Murphy tried at the very least separately, so that there's not the spillover that comes in. Because clearly the most damaging of the evidence that came in was evidence that would not have been cross-admissible in a separate murder trial for Tabish, even assuming Tabish and Murphy were tried appropriately together. If there are any other questions, I'd be happy to respond. Otherwise, thank you so much, Your Honors, for your consideration.
Thank you very much, Mr. Dershowitz. This case will stand submitted. I must comment that it's always been my opinion that justice is best served by great advocacy, and that's what we've seen today. Thank you all very much. Court's in recess until 11 o'clock.
Court is in recess until 11 o'clock.